Hi, everyone. It's good to connect with you again. It's my pleasure to introduce you to Professor Theo Myhre, who's a scholar and a professor in our School of Law. And he's the first law faculty member that's speaking to you and speaking to this class. So I hope you enjoy his lecture. I certainly did. He is both a legal scholar, but he's also very well educated in the humanities and history and in literature. So you'll enjoy his background and his teaching. He's also a very, very good educator and a good teacher and has won awards for his teaching. He's doing something really important here. He's talking about more than 200 years of legal education in the United States. And he's suggesting that legal education has caused a problem, may even, in fact, be undermining our democracy. So listen to the point that he's making about this. And he's suggesting in the end that we should all be educated in the law. So I want you to listen and think about what it is that he's saying. Listen to him carefully, take out a notebook and a pen or a pencil, and just follow carefully, because he comes to a point in the end that legal education ought to change and ought to fundamentally change. So my question to you, as you listen to Professor Myhre, what does he say is the fundamental problem in legal education, and what can we do about it? What does he think we can do about it? But I also want to know, what do you think we can do about the problem that he lays out in legal education in the United States? What does he think we should do about it? What do you think we should do about it? So thank you for listening. Pay close attention to Professor Myhre. Something important he's going to say at the end, and some important suggestions for you and for all of us in the end.
Hello, I'm Professor Theo Myhre from the University of Washington School of Law, and I've been invited to provide this presentation as part of 2020, the course at the University of Washington. Now, when Ed Taylor first invited me to participate, I was fascinated by the idea and became very excited because of Ed's approach. Ed's approach resonates with something that really only the wisest faculty members I've seen do, which is this: whenever there's a controversy or struggle, or somebody is very, very upset, rather than respond with defensiveness or ire, instead, the approach is simple: to pause and say, look, there's something going on here I don't understand. Will you please tell me more? Explain to me more about your experience, what you're thinking, what's happening, or what's going on. Right? Why I think this is a wise approach is because it opens the door to use our intellect and our empathy for understanding, and it creates mutuality, right? Both people in that situation are actually engaged in a really deeply meaningful exchange. And I think 2020, the course, may open the door for us to use the same approach. So what I'd like to do today with you is to address my work as a faculty member from the School of Law, and to put it in context with what's been going on in 2020. Now, I've been given three prompts. One is to talk to you about sort of the impact of 2020 on me personally and sort of as a scholar. The next is the impact of 2020 on my scholarship and my work as a faculty member. And then the third prompt, which is actually probably the most important prompt, is where to from here? What are things that can be helpful or useful to people, which is really what can be done, or what can be done. So delving into the first question, so what's kind of happened for 2020, or the impact of 2020 on me personally and as a scholar? I'd have to say the biggest impact is actually the impact of social isolation. In my personal life and in my teaching, I really value human interaction. And so all the nonverbal communication, when I'm in a class, I can see how people are reacting, their facial expressions, their body posture, small movements, whether they're leaning forward or backwards, anything like that. And in teaching remotely on Zoom, what I get are small boxes of people's faces. Sometimes the video camera is angled up, so it's only a nose that I get to see, or some eyes. And then sometimes people just don't have a video camera on at all. So I get frustrated by a lack of subtle information and the relationship that information can build between people. So it's actually had an impact on my ability to sort of connect and mentor. I try and overcome that, but you have to do it very intentionally and very slowly. I also really miss the casual interactions in a learning community where you're in a cafe and people are studying and talking and you hear all these conversations and really interesting music is playing in the background. And I have a huge sense of curiosity about the world. So people are a wonderful thing for me as a way to be playful and to learn and to grow and to just be part of that whole learning environment. So I miss that. With the shelter in place, it becomes more difficult to access that. I think one of the other things to just to be aware of in terms of deep impact actually is the way that the Black Lives Matter movement and the protests that happened this summer and are ongoing at various points across the country and sometimes across the world is that they're pointing to something that we can, in a previous moment in time, blithely ignore if you've got the privilege to do so, which is inequities in our social structures. All right, so most of us prior to COVID-19 had a lot of busy work, right? There's lots of meetings we had to go places, be places, travel a lot, do all these sorts of things. And that takes the focus off of sort of the deeper structures of how things are because we're dealing with the surface requirements all the time. And so I actually really appreciate the higher internal focus, which then allows for more introspection about what's actually going on. Now, I do want to say this: the BLM movements and the equity movements really are some of the most important social movements we have seen in decades in the United States. Perhaps since the sort of the mid 80s around the AIDS crisis, or in the 70s around women's rights, or in the 60s around racial justice and equity. And so even though we've come back in time again to take a look at the racial equity question, the racial equity, the way civil rights operates, is not separate and apart from gender equity, sexuality equity, rights, other kinds of equity questions. They're intertwined. The law that is used for civil rights is the same law that gets used in a variety of contexts. And so for us in the BLM and equity movements, I think putting our focus directly on how things are structured and how they could be restructured is of crucial importance in the history of our culture and our country. From 2020 forward, we might be different people in the future than we have been in the past. And I think that possibility is very encouraging. The struggle is daunting. All right, the struggle is daunting. And with social isolation, joining with other people becomes tough to do, right? It becomes really tough to do. So we have to be very self-conscious when we do that. I think this course is one of those interventions in how to connect and understand and move forward. So I'm very happy to be part of this. Okay, moving to the second question, the impact of 2020 on my work as a faculty member and my scholarship. I have to say this, that in 2020, the BLM movement and the racial equity and other kinds of equity protests that have been going on have made me rethink legal education. So let's talk legal education for a moment. And what I'm about to say here is something that I'm hesitant to say because the article I'm working on and this particular idea is something that without tenure can get one fired. All right, but I think is highly, highly important to say, and to understand what it is that I'm saying, we have to go back in time a little bit. All right, so legal education is actually, I think, one of the things that has contributed to the problems we're seeing in 2020 for a couple of different reasons. But I'm simply going to say this in a kind of a provocative way. American legal education has actually led to the undermining of democracy and, frankly, to the killing of racial minorities and poor people. It is directly connected to those results, and here's why. Right, from the history of legal education in the United States comes two very strong qualities: elitism and exclusion. Okay, now originally people who would study to become lawyers or to learn the legal system would actually be apprenticing to somebody who was already a practitioner, and they would learn the ropes from them, and then they would go and practice law, and they would take people in under their wings, and they would train them, and so on and so on and so on. But in about 1817, we had the formation of the first law school out of Harvard University, and that began legal education. What happened, though, is something that looks a lot more like a guild structure. All right, where there then became sort of entrance requirements to who could become an attorney, and these requirements are not equitable. These are not equal requirements. These are requirements that really drew people from more elite backgrounds. And so what you saw was sort of the development of a learned profession, like being a doctor, being a lawyer. But that learned profession meant that there were few people who were allowed to go there and get that education. All right. The other thing that happens in the history of legal education is that you have to have the law degree for regulatory reasons. So with every state in the United States, there is a separate licensing scheme, and the main qualification for that is your Juris Doctorate degree, right? Is your law degree. So to even practice law, or to take the bar exam in order to practice law, you have to have had the legal education first. Now, there are a few very small, tiny exceptions to this, but this is primarily the way the structure has gone. What this means is that legal education has been separated out of regular education. All right, so and legal training is compressed and consolidated into this very small group of law students. All right, and from that group, then those law students can take an exam and pass the bar, and then they become licensed attorneys to practice law. Judges are drawn from the pool of licensed attorneys. All right, so very small amount of the population gets to go to law school. Those who finish law school have to take a bar exam. A smaller grouping of those people pass the bar exam, and then judges are drawn out of that even smaller group of people. Right. One of the other realities is that a huge percentage of our legislators, either in the House of Representatives or the Senate, are often people who have law degrees. So even in a representative democracy, the people that we are choosing to represent us tend to be attorneys of some kind. So they're even drawn from that very small pool and become an even smaller pool. All right, that excludes everybody else from the legal process, right? Everybody else is excluded from the legal process. So regular citizens don't become judges, right? And people who don't comply well in education and have a fast learning curve, they don't get to go to law school, right? So you're starting to tailor legal knowledge and legal skills to an extremely small group of people. Right, and that group of people is not balanced demographically between all the different parts of society. It tends to come very heavily out of middle class or upper middle class grouping, and there are racial dynamics to this. Vastly Caucasian is the racial dynamic. Right, so people of color, the whole BIPOC issue is not representational demographically in either legal education or legal practice or in the judiciary or in lawmaking at the legislative level. Okay, so what happens is 203 years of this, right, creates a populace who does not understand law, who has been given no legal education or understanding. Right? And yet, a lot of the things we are seeing this year all has to do with law, right? Legal questions, legal implications, regulatory problems or struggles. the marginalization of people of color, the racial violence that is happening for law enforcement, right? The way qualified immunity works, things like this, are all tied to the legal system and to legal education, right? So legal education actually is something that we should focus on when we're thinking about racial equity, when we're thinking about social equity, when we're thinking about gender equity, right? All these forms of equality need to be brought to bear in a critical look at legal education. Now, I think that one of the sort of more complicated points here. So this is where being a legal expert puts a particular challenge on me. And the challenge is this: how to explain something that is a complex legal concept to an audience of smart people, right, without legal education. So your high school teachers did not have a law degree. Your junior high teachers did not have a law degree, right? And so it's simply not taught. Teachers are not taught to teach law, because law is isolated in a law school. And law schools in the United States are graduate schools. You have to have an undergraduate degree before you can go to law school. Other places in the world, law is actually taught at the undergraduate level, right? And so people are able to see or experiment or pursue law at an earlier time, and you can be more generally equipped with legal understanding and skills. But for us, it is really this elite few, right, that do it. And I think that makes it very difficult to make education available and useful to everybody. But that's where it needs to go, right? That's where it needs to go. Now, there are a couple of different things. So let's look at the undermining of democracy for a moment. So within the legal system, there's discussion of mass incarceration, right, and discussion of police violence. The situation that is presented there is candidly speaking heavily tied to poverty and to race. All right, that means that our prisons are filled with people who are frankly poor. All right, that is where that's the main populace in the prison system are poor people, and people who are the victims of police violence are also poor people. Now, the racial overlay between poverty and race, right, means that a huge amount, and in the Venn diagram overlap, the overlap is significant. A huge amount of the people in mass incarceration are BIPOC. Especially African American, and a huge amount of people who are the victims of police violence are also BIPOC, right? Especially African Americans, and so that gives us a disproportionate system, right, in the criminal justice system and in law enforcement. All right, that is disproportionate. The facts are undeniable for this, all right? But the solutions are not easy to come by, because not even the police are trained in the law, okay? They don't understand what is happening in a given statute, let alone a given judicial opinion, interpreting the Fourth Amendment or something like this. So actually, let's talk about judicial opinions. So the U.S. Supreme Court, right, is the court that's created by the U.S. Constitution. And one of their jobs is to provide oversight or overview of the legislation that the legislative branch passes and the chief executive, the president, signs into law. And what they do when they provide oversight is they make sure that law complies with the requirements of the Constitution. All right, and in the Constitution there is the Fourth Amendment. Right, and in the Fourth Amendment, there are several different clauses that are important to us. But in that Fourth Amendment is the set of clauses that are highly relevant to police enforcement of the law. And this is where warrants can be found. This is where what we view as the stop and frisk set of issues come from for police. And what you have in relation to warrants and to stop and frisk is a racialization of the Fourth Amendment. All right, and what I mean by that is that the cases that have come before the Supreme Court look on the surface to be dealing with a set of facts or circumstances that then is applied to sort of a constitutional standard, and they see whether the behavior complies with the standard. Right? What the cases ignore is the racial component, which is to say the judicial opinions ignore, when the judges are looking at the situation, they ignore the race dynamic, all right? And they focus on a more generic version of the behavior, right? But time and time again, when the court says that the police have complied with the constitutional standards or their policies comply with constitutional standards, the situation has involved people of color, okay? And most often it has involved black people. So what we've got then is a build-out of constitutional law. And this is what you have to understand about constitutional law. In the United States, we're a common law system. All right? This means that the way a judge decides a case, the way a judge interprets a statute and applies a statute in a given case becomes part of the law if that case is published, and certainly if that case is at a high enough level like the Court of Appeals or the U.S. Supreme Court. What that means is the Constitution isn't just the document of the Constitution. The Constitution is the document plus the cases that have interpreted and applied it. All right? It's also the statutes that have been empowered by the Constitution that build out the law and regulations in that area, whether it's the Commerce Clause or criminal law or whatever it might be. So what we have in our legal system is a very complex legal document that is the Constitution, statutes, and cases that have interpreted and applied them. So it's a three-part construction of the law. The interaction between those three things usually takes people all of their law school experience to understand, which is 3 years at the graduate level, and then really about 3 years of practice. So it's kind of a 6-year process. How other people are supposed to understand this, including the police, I do not know, actually. I do not know. But we need to be aware that that is the structure. So when we're talking about the racialization of the Fourth Amendment, what that means is the court is sterilizing the fact patterns, right, that they're seeing in an individual case. They're interpreting and applying a statute or regulations to those fact patterns, and they're seeing if they comply with the Constitution. And when their answer is yes across the board, right, what you have is a build-out of the Constitution that is now racialized. It embeds institutional prejudice inside of it, and that prejudice is a racial and economic prejudice, right, where it's poor people and people of color. And so that alone is something that we need to address, and we need to address that as a society, because if the legal profession were able to actually see that all on its own, we wouldn't be where we are now. All right, if judges were able to see this, if attorneys were able to see this, if legislators were able to see this, we would not be in such an inequitable position if people want to be fair to each other. So let me say this about justice. Justice is not a naturally occurring thing. All right, and equity is not a naturally occurring thing. They are a human thing. We create them. We promote them. We develop it. We resist it, right? We do everything involved with justice and equity from both sides of that fence, to shrink it or to grow it, right? To create it or resist it. And so the justice system reflects who we are. Law is a cultural creation. It is a tool, and it is a tool that can be used for good or for evil. One of the things 2020 has brought us is an understanding that the tool of law is causing harm. right? More harm than good in certain communities with certain people over a long period of time. Okay, does it have to stay that way? Right? Does it have to stay that way? The answer is no, right? We are tied to our history, right? But we are not limited to only our history. So we can evolve the law around these things. That is actually possible to do, but it will take a concerted effort, right? And that effort is going to have to be from the legal community, from the political community at the highest levels of policymaking, and from the social community, all right, at large levels like the country or states or counties, at more local levels like your city or your area, your neighborhood, and in more personal areas like your friends and your family or your work networks, right? Pressure to change must come simultaneously from all of these areas. All right, I think one of the things I'd like to talk about here actually is in the more social sphere, which is the creation of law, or law in the democratic sense. Okay, so I said that law schools undermine democracy, and here are some of the ways that it does that. So one of the ways that it did that, right, was to utterly deny legal information, education, or skills to anybody other than an elite group. But it also means that in public education, not necessarily in private education, but often even there, we have a very limited understanding of civics. Okay, often the civics we understand is there are three branches of government, and then there may be a schoolhouse rock song called "I'm Only a Bill," and that tells us sort of how law is made. But those barely scratch the surface. We need a much more complex understanding of civics, and so within the civics development, we need to know more about the relation between the branches of government, the pathways that law takes or legislation takes when it's being turned into a law. All right, and there are things that actually interrupt democracy along the way, or really cause serious struggles or weakenings of the democratic process. One of which is lobbying efforts. Okay, and another of which is a line of cases that the Supreme Court has put out, starting with Citizens United. So here's the situation. In the Constitution, we have the amendments in the Bill of Rights, and the First Amendment, of course, is freedom of speech, and what they're talking about most strongly is freedom of political speech. All right, now, we have in a line of cases from the U.S. Supreme Court built out the idea that political speech is not just for natural persons, but actually business entities have free political speech too. Okay, this is an absurdity, an absolute absurdity. All right, the businesses they are a legal fiction, right? They're not an actual entity. And so they cannot themselves vote. And yet, without the ability to vote, we give them political free speech based on cases like Citizens United from the U.S. Supreme Court. What that means is that businesses can contribute money to political campaigns. So political speech in this case is money. And if we follow the money, what we find are lobbying efforts intervene in the democratic process. And they intervene in the democratic process in a lot of places. But one of the places is in committees and with elected officials or representatives. And so rather than the public being able to voice what its concerns are, these sort of corporate entities will come in. Also, private individuals may band into a group, into a pack of some kind, or into a specific interest group, and that group will try and exert more influence than any one group or one voice ought to have. All right, so lobbying is one of the things that's been legally recognized, but actually is incredibly harmful to democracy. Another thing that has been legally recognized and allowed is voter suppression. All right, and in voter suppression, there are so many different facets to voter suppression, most of which have been recognized as being legal. They are not right. They are not ethical. They are not moral. But our legal system, the way the Constitution has been interpreted, the way statutes have been interpreted in a common law system, allows them to happen. Right? Another issue that's sort of arisen is the political polarization of the court, which means members of the judiciary are being nominated at the federal level not based on their abilities or knowledge of the law, not based on their relationship to jurisprudence or really the whole overarching structure of law, but actually based on political ideology. All right, and that means that the decisions you're getting at the Supreme Court level or in the federal court level can have more to do with the political ideology of the judge than they can to do with actually law and justice. All right, and that's not a sustainable legal system. All right, that's not a sustainable legal system. So the ideological polarization of the court is another area that undermines democracy. And sometimes that's hard to access or realize, that the sitting president and the majority of the Senate sometimes are less important for the laws or policies they adopt than they are for the judges that they appoint to the federal judiciary, because those judges serve for a lifetime. All right, they are not there for 4 years or 2 years or 6 years. They are not directly elected in a democratic sense. They are appointed and confirmed by elected representatives, but then they stay there until they retire or die. All right, and so this creates a kind of a conservative or an ideological force that is difficult to remedy in a democratic sense. All right, so another key aspect that a lack of legal education has allowed to happen in terms of undermining democracy is, excuse me, is the development of a two-party system. All right, and in a two-party system, it's winner takes all. Many democratic societies around the world use a multi-party system, which are almost like affinity groups, right, for political beliefs or platforms or things like that. And because in a multi-party system, there's not a vast majority, the different parties and groups have to work with each other. This has a very moderating influence. We are not seeing moderation in the United States right now. We are seeing immense polarization, almost at the 50-50 level or 49-51 level, right, between rather tough sets of viewpoints that really have a huge impact on society and fairness or equity or equality in society in a number of vectors, right? With immigration, with race, with gender, with LGBTQIA issues, right? These even with religious tolerance, these are things that we're struggling with. So within that context, the isolation of the United States into a two-party system rather than a multi-party system has a devastating impact on the creation of our laws and the way politics, normal, usual, regular politics works in the United States. That's something that we should remedy. There are many states that only allow for the two parties, right, to be represented. Other states will allow for more. But those parties have a very difficult time being established or having longevity over long arcs of time. All right. What I'd like to do now is actually maybe talk a little bit about solutions and simply summarize it like this. So, with basically 200 years of elitism and exclusion in legal education, the disempowerment of the populace. I mean, even the sitting president does not understand civics and law effectively, right? So it's really from the lowest to the highest level that ignorance in the population for law is intense and long-standing. So we need to do something about this. So our question now is, where to from here? What can be done? What can I do? What can you do? What can we do? And I think the first answer to this is expand legal education. Right? What do I mean by expand legal education? Well, legal education has to be for everyone. It's got to be for all of us, because we're all subject to the law, and we all live with the legal system that we have, including our political system. So public education especially, right, must place legal education into its curriculum. And it needs to do it at the secondary level, probably even at the primary level. At least by 6th grade, we need to be moving law and civics heavily into the curriculum in junior high or middle school and in high schools, all right? Legal education has to be there. So that means that we also need to take and open up law schools, right, to undergraduates as well. Legal education needs to be in higher education, but it needs to be at all levels of higher education. All right. We also especially need to train teachers in legal education. There has to be something that happens there. Now, that training, right, that curriculum, the existing attorneys, existing law faculty really need to assist in this process. But you have to demand it. All right, you have to lobby for it. You have to push institutions, law schools, your schools to open up their curriculum to legal education. And it needs to be there. And you need to find it for yourself also. When classes are offered, take them. Right? When lectures are possible, go to them. Right? Watch them. Really empower yourself with those tools that knowledge and skills can provide. We also need to make sure that legal education is making its way to law enforcement and to public officials. All right, so the police need to receive legal training. They need to understand the boundaries of the law. They need to not push those edges. All right, it would be very helpful if we actually began to create regulatory schemes that regulated the police much more effectively. So the use of legal skills and knowledge can really be something that occurs in each of the areas that we're looking at, right? And especially with law enforcement, and especially with populaces subject disproportionately to law enforcement. Those are immediate areas we need to push legal education into. All right. The other thing we need to do is to eliminate voter suppression. All right. We need to stop gerrymandering. We need to address polling restrictions. We need to get the Jim Crow laws off the legal and political table in states that allow disenfranchisement in very, very subtle, racially charged ways. We need to perhaps think about creating a voting day holiday so that poor people can vote without getting fired from their jobs, right, or missing work. We need to require states to provide vote by mail or neighborhood collection boxes, or to address any number of other polling problems that are there. You have to have properly funded staff and voter confirmation processes, right? You've got to review those processes and fix problems as they occur in a really timely way. We need to automatically register people to vote when they turn 18. All right, the same way that we used to do something like that for the draft, right? If you think the Vietnam War period. And then you need to require reasonable accommodations for public health and safety in voting, particularly around COVID-19 or other restrictions that place the burden on voters rather than on the government to help you or to help facilitate voting. All right, we really need to get voting rights for incarcerated people back. All of the people in the mass incarceration system have been disenfranchised, and the vast majority of those folks should be able to vote again. All right, so part of our solution then is to modify the political system and its practices, right? Eliminate something like Citizens United so that it's natural persons that have political free speech, not companies. We need to get a multi-party system in place, and we need to restrict and prohibit lobbying because these all distort the democratic process. We need to actually, so let me just speak sort of more personally or candidly. Right? I firmly believe, as I've said, that we're tied to our history, but we don't need to be exclusively limited by our history. And that means that our legal system can do exactly what Martin Luther King told us it could do, that the arc of history tends towards justice, all right? That is only true if we push it in that direction, all right? Justice is created for people, by people. And we need to make that arc towards justice one of our top priorities. And legal education and modifying our legal system is the way to make that happen. So I would like to see us move in the direction of justice and equity, right? Not in the direction of elitism and exclusion, right? That is the wrong direction to go. That is what ties us to 200 years of history in our legal education and in our legal system. We need to expand it. All right, law, being a human creation, is a tool to be used for good or evil. And if we want it to be used for good, right, then we have to work to make it so. I think we begin with legal empowerment. And so at the conclusion of my presentation to you today, that is my admonition. Let us legally empower ourselves to make the changes for equity and justice. All right, thank you, everybody, and I look forward to the interview with Ed Taylor, and I wish you all the best of luck. Stay healthy, stay wise, and stay powerful. Bye for now.
I'm so pleased to have Theo Myhre here to as a preface to his lecture, to have a little discussion about what I thought was a wonderful lecture, Theo. So thank you so much. And before we start to talk about your lecture some, because there's such great depth there, let's go back to young Theo when you were an undergraduate student yourself. A number of our students are undergrads. We have some graduate students as well. You started out at Evergreen, and I'm assuming you were young when you went to Evergreen, but talk about how you got to Evergreen and how Evergreen shaped your thinking. Did you know that you wanted to be a lawyer when you went to Evergreen?
Sure. I'll answer kind of both parts of your question. So I grew up in Spokane and went to public schools and then ended up going to Gonzaga Prep High School. And one of my good friends from early on in school actually was a year ahead of me and ended up going to Evergreen. And he invited me to come visit for the weekend. So I went and then stayed a few days. And he was like, well, come to class. The professors are fine with visitors in the class. So I went to, it was kind of a political science class. And there was a professor named Burl Crow. And Burl is, he's a very craggy, very old face, smokes like a chimney. He was very intense. And he was talking to the class and engaging kind of a dialogue, and he spotted me and trotted over on the stage to me and began to ask me questions. And I began to answer, and we just went back and forth, and then he brought other people in to back and so on for probably about 30 minutes. And I thought any school who does this is a school I want to go to. And my entire experience at Evergreen was that way. It was very engaged, it was very dialogic, and the faculty were all mentors. And my whole 4 years there was like this. And the impact of Evergreen is its interdisciplinary thinking. So all problems have a variety of viewpoints to them. All solutions have a variety of approaches to them. Everything is interconnected. And that, I thought, was just one of the best kinds of education that anyone can have, because you're always thinking in a more complex way.
And you knew something about the law, and what was your thinking about and your approach to studying law when you were an undergrad?
Yeah, so I resisted going into law and becoming a lawyer because my stepfather was a judge in Eastern Washington, and my uncle was an attorney there. And so I just grew up with the law, was very comfortable with the law, but I wanted to go to grad school and become a teacher. I actually really wanted to become a professor of some kind. And the professors I resonated with the most were historians. They seemed to sort of reach their peak in their 50s or their 60s. They read everything. They were very thoughtful, very smart people. And I thought, that's a great career for me. But eventually ended up shifting away from a PhD in history over to law, sort of the next learned profession over.
So you're able to get graduate degrees in history and modern intellectual history.
Yeah, so historians always have their subfields. So I did modern European intellectual history was really my specialty. History of ideas, that sort of thing.
Mm-hmm. And then you got your JD. Then you actually succumbed and you went to law school at Seattle University.
I did, and had a really interesting experience after that. I got to clerk for Justice Charles Johnson with our Washington Supreme Court. And that was an amazing experience working in Olympia and working on all the Supreme Court cases there. And then did civil litigation downtown. So I was one of those dark-suited attorneys doing depositions on behalf of corporations and things like that.
Speaking of the Washington Supreme Court, I saw you quoted recently, and the quote that I saw associated with you was that it's important for the courts to go back and recognize and acknowledge mistakes. And so 2020, there was a mistake that the state Supreme Court had corrected in 2020 that I hadn't noticed until I saw the court. Describe what that mistake was and how that was repaired by the courts.
Well, the case just came out actually last week, and it was looking at initiatives in Washington that gets turned into statutes and whether or not they comply with the Washington Constitution. And way back in the 60s, there was a decision where a statute regulating cemeteries prohibited them from discriminating or segregating in the cemetery, having a separate but equal policy, because that was seen as a civil rights part of the statute, and that meant that there were two subjects going on in the statute, and that violated the Washington Constitution. So that came up again in the most recent case, looking at whether an initiative is constitutional or not. And the Supreme Court struck that case down. And it's not that cemeteries could segregate or discriminate on the basis of race from that earlier case until 2020. It's that that case got removed as legal precedent. And the tapestry of civil rights laws, actually, they came in place of that statute. And prevented cemeteries from discriminating in that way. But the concurrence in that 60s decision was so racist. It's appalling by contemporary standards. But the rhetoric we see in that is rhetoric we're hearing today in some of the most aggressive and sort of on the margins arguments on race in the United States. And it's really important when a court, which is they're in control of a whole branch of government, goes back and says, this was wrong. This was wrongly decided, and it has embedded racism into the judicial record, and we need to excise that. The court needs to be neutral, and it must not say these things, right? So I really applaud the court for actually doing that, even though it's so long after the fact. The court did the same thing, for instance, at the federal level in Korematsu, looking at Japanese internment. And the court has gone back and said that was a wrongly decided case, right? And so it's vitally important for institutional equity that the court actually acknowledge its past errors and correct them.
I want to come to that point of the court must be neutral. But before so, in your lecture as you started out, so let's come to the content of your talk. You talked about some of the things in 2020 that have impacted you personally. And one of the things you described was the impact on your teaching, because you talked about the importance of nuance, the kind of intricacy of teaching, seeing students, feeling students, the little gestures that they make. You also talked about the act of just sort of being at cafes and listening to music and hearing the sounds and listening to people. For you and your teaching, all of that seems to matter. All of that seems to feed you. Talk about yourself as a teacher, and even if you wouldn't mind, describe the ideal in-person classroom for you and how you draw energy.
These are great questions. So there are a lot of different approaches to teaching theory, pedagogy, or to learning theory, how people learn things. The COVID-19 and all of the social isolation that's taken place makes people in their heads an awful lot. Right. So suddenly learning has actually become an isolated experience. It's almost an individual thing. It's you and your computer, or the video you're watching, or the book you're reading, or something like that. But when classes are in person, learning is a social experience. Right. It's not only what you're internalizing, it's everything that's happening around you at that moment. And I think our brains pick up on that. So when we start to integrate ideas, we're integrating them with all of the context attached. How we learned it is sometimes just as important as what we learned, and also who we learned it from. Right? These are all kind of present. So in classes, I love it when I can see people and I can see if they're leaning forward or back, if their feet are crossed, what their body posture is, their eyes, are they open? Are they squinting? Is somebody having a concerned look? You can tell if people are engaged. You can tell the reaction they're having to it. And I use those as opening moments. So if I see that there's a wobble, that's the student that I can draw out and simply ask, all right, what's the wobble about? So if you're making this face, or you were leaning forward, but now you've gone like this, why did that just happen? And then since it happened with that person, it probably has happened with many other people in the class. And I can really use that as a way of getting beyond sort of defenses or getting beyond apathy and really engaging with the people in the class so that the information and the people and the learning environment are all joined together. And that, I think, is a powerful experience. It's hard to do that on Zoom, right?
And you're a law professor, so you've described something that sounds very different than the paper chase model, where it's a crusty professor in the front of a room chastising people for not getting facts right. It sounds like something very different for you.
Yeah, the paper chase model, it's actually, the Socratic. So we use the Socratic method a lot in law schools, but the paper chase method method is a failed Socratic method because they push a student to the point where they can't answer the question anymore, or what they're saying is inaccurate, and then they move on to a different student. An actual Socratic model is you push to the point of failure, and then you help them build the bridge to what you want them to know and understand before you move to somebody else, right? So law school can be brutal in that way because it has a sort of a misdelivered technique.
So the two things that you pointed out in terms of a personal impact that I thought were interesting: one, social isolation and its impact on you in teaching, although you've made the adjustment to online and virtual for the short time, hopefully, that we'll be doing this. But the second thing you mentioned was the power and the impact of the social movements of 2020, which you said are the most important that we've seen in decades. And you compare this to the AIDS crisis in the 80s, to the women's movements in the 70s, and the racial justice movement in the 60s. You see 2020 as having that kind of impact, and you call out Black Lives Matter in particular. Talk about the power of this year, such that it makes it comparable to those movements.
Well, okay, so I think what's important to know from a legal perspective is something that people may not realize just in a sort of from a general public perspective, which is that civil rights build on each other, right? So there is no equity movement in the history of the United States that is separate from other equity movements. So an example of this is the 14th Amendment. So the 14th Amendment is arguably the most powerful amendment in the U.S. Constitution. It's the post-Civil War amendment, and it's what has the Due Process Clause and the Equal Protection Clause sitting in it. And those clauses, even though they arise in a post-Civil War race moment, are what were used to advance civil rights for women, right? So gender civil rights comes right out of the 14th Amendment. The 14th Amendment was not limited only to race. Once it takes that step, it's racial and then it's gender. The LGBTQIA movement, right, gains its civil rights based on the expansion from race to gender, from gender to sexuality. Now you have a return back to addressing gross structural inequities based on race over a long period of time, but you have the development of gender equity and LGBTQIA equity, right, or equality, to then strengthen our revisiting of racial equity. And it's vitally important. So the cases in a common law system, the cases build on each other over time. And so you don't get same-sex marriage if you didn't have Loving v. Virginia. right? These are deeply dependent on each other. So now when we go back and look at anything, we can look at the current line of cases to help strengthen those who have been marginalized. And so it becomes, what's happening with the social movements is it puts it front and center in our consideration, and it makes us actually deal with them. So people are challenging the way the police operate, for instance, and the kinds of common law or legal precedent that looks at how police are excused from the actions that they're taking, right? And the impact that has.
So you thus make the case that we might be different people as a result of 2020. I want to move into what you described as the impact on your work. And the first thing I want to say to you, Theo, is I want to thank you for the candor with which you brought to this talk and this lecture. And because you say that 2020 was made you rethink legal education. And this also sounds like some work that you're doing in an article as well. And you have a really powerful hook here, because you say that you're about to say some things that someone without tenure could get one fired. So how did you get to the point of thinking that this is what you wanted to say to this class? Before we talk about what you've talked about, that's a powerful thing to say, it's a powerful hook to say, what I'm about to say to you, someone without tenure could get fired for this. Tell me your thinking as you led up to what you wanted to say to the class and to the public.
Yeah, well, there's so much that goes into this. All right. So, I've been kind of in civil rights advocacy for really my whole adult life. And being part of law has been a really powerful experience. And being a law professor has been incredibly fulfilling. But the law schools themselves occupy this very strange space because they're a graduate program, they're a professional program. They're usually kind of isolated from main campus, despite the fact the school sits on main campus. Law faculty rarely teach anyone other than law students. And yet all of these social issues we're dealing with are legal in nature. They are legal struggles and challenges. The dynamics that are causing inequity are all legally approved, right, that are there. So the question is, how did the current crisis we're seeing, as raised by Black Lives Matter and the other equity protests over the summer, how did that actually come into being, and how is it perpetuated? And I began to think about, all right, well, since these are legal questions, how did legal education play into this? What has been its role? Because before now, we never talk about legal education. You don't see it on the news. There's not a headline article, legal education rethought, right? That's not there. We don't debate it when we're having coffee. Families don't talk about it over holidays. It's not something we think about. But thanks to COVID-19 and the protests, I started thinking about it because education is very important to me. And what I realized rapidly, and part of this is my background, right? I have a history background. So I look at things as they evolve over time. And what I saw as legal education evolved over time was massive exclusion of people from legal education and a real narrowing of legal knowledge and legal skills to an elite few. And that has a tremendous impact on what we're seeing in the world today, particularly in the US at every level of government and politics.
Such that narrowing has led to what you describe as the undermining of democracy and possibly the killing of racial minorities and poor people in this country. It
does. Just in a phrase, because legal education has become so exclusive, the general populace does not understand what is happening. They don't understand how the Constitution is interpreted. They don't understand how statutes are interpreted and applied. They don't understand how law is enforced. They see bad results, but they don't understand the process. And this is true also of teachers, right? So at every level of education, law is not present. It is systematically reserved to law schools only. And the law schools are what produce the attorneys. The attorneys, that group of licensed practitioners, those are who produce the judges, who interpret and make their rulings in the common law system. The legislators, a huge number of whom are attorneys, right? So the majority of legislators are disproportionately representative of attorneys, right, in the system, which means you have this very elite group participating in all of these many, many ways, in a way that the general populace can't, the way teachers can't, the way undergraduates can't. We may want to know these things, but we don't even know what we don't know.
So this goes back to the 19th century with Harvard's first law school.
Yeah.
We move from an apprenticeship model to a guild kind of structure, and there's a narrowing of who gets into law school, who gets a legal education. You're not so much problematizing those people that have a legal education. You're problematizing the fact that so few people get access to this education and this.
Correct. Yeah, I mean, there are, one thing to understand about law is that it's a cultural artifact, right? Every society creates its own legal system. They're all different from each other. Ours is very culturally particular, right, in its form and what it does. But it's also a tool, and it's a tool for good or for bad, right, for equity or for prejudice. Right. And it depends on who's using it and how you use it. There are amazing judges, there are amazing attorneys, there are amazing legislators. But there is also an enormous history of people in the legal field not looking at critically equity issues.
So you said that law is a cultural creation. We created this. It's not objective. We've created this. And we've created this in ways such as stop and frisk. So for students that aren't from here, don't understand this concept, describe what stop and frisk is and how that relates to and how that helps create the structure of inequity that you're describing.
So this is where the fact that we're a common law system becomes really important. So we're different from other countries in this regard. So in the U.S. Constitution, there's the Fourth Amendment, and the Fourth Amendment has the protections that we would think of, or the clauses that apply to things like warrants when the government needs a warrant or police need a warrant to do what they want to do, or warrantless searches, right? And so the warrantless searches, the ones that don't require a warrant, things like stop and frisk arise under. So this is where the police, for whatever reason, say that there's something in the circumstance that suggests an investigation is necessary. And then they have the ability to stop you. And you're actually engaged in a constitutional dance. Virtually no one knows they're in a constitutional dance. And the police don't even understand, because they don't have legal education, right, that this is a constitutional dance they're undertaking. And what they'll do is they'll ask questions. The more information you give them, the more questions they can ask, and so on and so on and so on. But the stop and frisk scenarios, right, are the ones that devolve rapidly towards violence, right? And this is where people lose their lives. Now, if you look at the statistics, the people who are killed during stop and frisks by the police, they do exist on a whole spectrum of racial identities. But the reality is that they are very largely poor people. The vast majority of them are poor people. And they are disproportionately BIPOC, really disproportionately African American. They're sitting in there. The way the laws are interpreted for stop and frisk, you have to follow this pattern. So a court reviews what the police have done, and they ask whether what the police have done complies with constitutional requirements. So the court is this oversight bridge between the two. The way the law works is the Constitution is not just the document of the Constitution. So the Fourth Amendment is not the language of the Fourth Amendment. The Fourth Amendment is that language, plus the cases that have interpreted and apply it. That's what the judges are doing, right? And then we have the situations that it's applied to. All right. And so in the situations where there is a racial component, there's this disproportionate violence happening against people, the courts are not looking at the race question. They're not looking at race equity as an issue. They're not looking at disproportionality as an issue. They're just seeing whether this behavior complied with this law interpreting this provision. And so they scrub it of race. And then they have a case that says, yes, the police in these circumstances, they complied. And then you get another case with slightly different circumstances, and so on and so on and so on, until the Fourth Amendment is built out to include permission for the police to do these things, but it's permission for them to do these things in specific contexts where race is present. And we don't acknowledge that race is present, right? So you have a racialization of the Fourth Amendment, and that's what we're dealing with in the United States, right? And then we have other doctrines like qualified immunity that help to protect police even further when there has been violence against somebody. Right. And initially, qualified immunity makes sense because you want government actors to be able to do their job without being sued. Right. But when so many miscarriages of justice are happening, this no longer makes sense. This actually is now where law, as a double-edged sword, cuts the other way. It's now defending injustice. And that's a problem.
So we have a system that has been built and designed and engineered over 200 years. In fairly complex and intricate kinds of ways. But yet you make a really important turn because you actually think there's some things that we can do about this. And you quote King, who quotes another Theodore Parker, Unitarian minister from the 19th century. The arc of the moral universe is long, but bends toward justice. You don't think it bends by itself. It has to be pushed toward justice. Say more about that.
Yeah, this is why it's really important to understand that law is socially created. Okay, we create it together. We do it over time. So we inherit a legal system from the people who came before us. But our legal system is not static. It's not fixed in one point in history. It develops from that. And if you view the legal system also as a justice system, right, also as a way of expressing society's values about fairness and equity, then you actually have to push the system to behave in that way. All right, because when left to its own devices, it will sit in kind of its historical rut. All right, but what we are seeing is that tool is being misused. That tool is causing harm. It doesn't have to cause harm. The tool itself is not evil. Right. And if we want the trajectory to bend towards justice, we have to make it bend towards justice, because justice is something we create. It's a living thing. Justice is not an objective. It's not an object. Right. It's a way of relating. It's a way of associating all kinds of behaviors and activities. So we have a job to do. We have work to do, which is to make sure that the arc bends towards justice and that it is a justice system that we have, right? And you have to be very diligent and very vigilant in this regard.
What I appreciated about how you left us in this lecture, Theo, you gave us a sense of how to do this. You didn't leave us with a stubbornly persistent problem that we can't fix. You gave us some ideas that, in some regard, seem very pragmatic. I know systemically they're not that easy. But in your mind, not only is the system, is legal education not elite and for the few, but actually it's quite democratic. So you begin to imagine a country where middle school teachers are trained in the law, where high school teachers are trained in the law, and legal education becomes something that is accessible to the many, not to the few. Talk about some of the things that you lay out that are very pragmatic, how we can begin to push and bend the arc toward justice. What are some ways our communities can be different? Because you also invite not just a few, but you say this is work that can be done in schools. It's work that can be done in our communities, in our neighborhoods. Talk about the solutions that you think that might be practical.
Yeah. So all right. I'm saying there's so much to say on the subject, but let me just start with legal empowerment. This is actually the solution. For when the general populace has been disempowered from legal knowledge and legal skills, and when the injuries and harms that are coming our way are based out of a legal system and legal enforcement, we need legal empowerment as an answer. That means legal education has got to shift, and it's got to shift dramatically. So law schools cannot maintain being isolated as graduate programs. They actually have to open up, and they have to begin to educating people. Undergraduate, so many countries, legal education is an undergraduate thing, right? Just not in the United States. But but since lawyers are just from this kind of graduate thing, teachers are not legally educated. You can't teach law if you don't understand law, right? It's not rocket science. It's complicated, but it's understandable by everybody if given enough time. So we need to go back in time and build that in, right? So we actually need legal education to make it into K through 12 education. Really, when the moment civics starts to come into it, law should come into it. You've got to educate the teachers at that level, and in grades 1 to 6, you need middle school teachers educated. You need high school teachers educated. You need faculty across the university educated in it. And then the education can't just stop in the educational system. We need our communities educated, because people have graduated from school now without legal understanding. We need to get it to them, right? So if there are lectures, if there are videos, if there are forums, if there are Masters of Jurisprudence programs, which we actually have one. I helped sort of Pat Kessler create one for UW. These are people who want legal knowledge but don't want to go to law school for 3 years, right? You can do that. You also need to intervene in the sort of political system that's sitting there, because a great deal of what's permitting the inequities to happen comes from policymaking, right? And the impacts of voter suppression on minority communities and minority voices. But if minority communities and voices were empowered legally, those voter suppression techniques would not be permitted. They would not be allowed. Literally, they would be taken off the books, right? And so that is a place that we need to go. And there are lists of voter suppression laws and techniques that have been existing in this country over the past 200 years. And some have come into play very intensely right now. And COVID presents a huge problem for voter suppression, but there are ways that we can handle it, right? There are ways that we can handle it. And so the political system needs altering. The things in the political system need altering. The use of law needs altering. And the access to law is the one overarching thing that can bring all of it together. Because it's not just we who need it, it's police also need it. Legislators also need it, right? It's a fundamental tool that anyone in our society should have access to.
I want to end with a question that has to do with you as a teacher. You won an Excellence in Teaching Award a few years ago, and nominated and selected by some of our top students at the university. One of the students, I remember a comment that the student had said, they enjoyed listening to you so much that if you decided you no longer wanted to be a professor, they suggested you become a DJ at not just a jazz station, but an alternative jazz station. And the students talked about how much they loved you as an educator. The final comment goes to you, Theo. What gives you hope as a public educator, not just an educator of students, but really an educator of the public? What gives you the most hope during times like this, like 2020?
There's a lot to be hopeful about. So let me approach it this way. I think relationally, right? That is how I really approach the world. And that informs every aspect of my teaching. So my teaching isn't about me. It's about building a bridge to help my students understand something they didn't understand before, and to give them the power and the tools to do something with that, whatever it is they want to do. So I'm very non-judgmental in this way. I let people come from where they are, and I just help them get to where they can go. And some people do it in a very messy way, and some people do it in a really disciplined way, and some people do it in a really informed way, and some people do it in a very loving way, and other people do it analytically. There's fill in the adjectives for how people receive education and do things with their education. When I'm looking at, say, the early fall start students, there is a real difference in the cohort that came in this year than has come before me previously. But I believe in legal education so much that I really like teaching us right to an incoming freshman group, because everybody has self-selected in, they want to learn, and they're very excited about it. And this particular group that came in this year was cohesively engaged with the BLM movement and equity issues. The amount of I would say concern and compassion and joining with trans members of the class, with racial minority members of the class, with women in the class. So the class was 2/3 women, actually, all wanting to know law, right? And women have been some of the most oppressed people under our legal system, right? Without the power to vote well into the 20th century, right? So there's, in that cohort, not an isolated identity politics, which we have seen in earlier civil rights struggles, but rather what they had was a cooperative, mutually supportive approach. And that, I think, is key. And that gives me a lot of hope that the upcoming generation is actually going to approach civil rights issues in a more complicated, more integrated way than we have before. They don't have to force the door open. Doors have been opened. Now they have to widen the doorways and get more people through them. And I think this group this coming generation is actually set up to maybe do that.
I think the fact of the matter is maybe that you are indeed doing jazz music and you're teaching at the same time. Thank you for being the educator that you are. Thank you for joining our class.
Thank you very much, Ed. It's been a real pleasure. Hello, I'm Professor Theo Myhre, and I'm here to talk to you today about an event that's in the news and everyone is talking about, which is the latest appointment to the United States Supreme Court, replacing the late Justice Ruth Bader Ginsburg. This raises a question for a lot of people, which is simply stated, do the members of the United States Supreme Court have an impact on civil rights, especially voting rights in the United States? And our answer to this is yes, for two reasons. The first reason is the membership of the court itself and how that comes into play. It's important to understand that members of the U.S. Supreme Court are not elected, and in a representative democracy, that looks a little strange. But instead, the chief executive, which is the president, nominates a candidate. That nominee is then subject to the hearings by the legislative branch, in this case, the Senate, who then passes the candidate forward for a full vote by the Senate. And once the Senate has reached a majority vote, then that candidate can be confirmed and appointed to the U.S. Supreme Court, which is what has happened to Justice Coney Barrett. Now, traditionally, however, that candidate is acceptable to the vast majority of the Senate. What we are seeing in the last several appointments to the court is a narrow margin. It is a bare majority, and it is really subject to the political parties that the members of the Senate have. So we're seeing votes of 52 to 48, 51 to 49, things like this. That means that a traditional check and balance, which is a moderate candidate, right, is being moved off the table, and more ideologically extreme candidates are joining the court. This unbalances the court in terms of political ideologies. The court becomes not representative, right, of society as a whole or the populace as a whole, but instead reflects the ideology of the party in control, either of the chief executive branch or of the Senate. And this has an impact on civil rights. What is the impact on civil rights, especially voting rights? This can be seen in an earlier case called Shelley, where the United States Supreme Court found that a renewal of a provision in the Civil Rights Voting Act from the 1960s was unconstitutional because all the data was from the 60s, which is to say, when people of color, especially African Americans, have had the inability to vote or a lot of voter suppression, that was used as evidence to support the enactment of the Voting Act, right? But that evidence was found to be significantly out of date, and therefore the renewal of that in 2006 was found to be unconstitutional. What this means is, in later cases, the more conservative Supreme Court has upheld certain kinds of voter suppression, such as gerrymandering, right, where the voting districts are being redefined as a way of diluting people's votes. Now, people will ask, if the Supreme Court is becoming more politically polarized, so that ideology rather than the law can become the major motivation behind a decision, what can be done? The answer to that question is resting with you, actually, with the public. So because the federal judges are appointed for a lifetime, and because there is this increasing polarization along political ideological lines, the check and balance in the middle, the moderate middle, is not controlling. All right. Instead, the ideology is controlling. So the judiciary, which has protected civil rights in the past, is not going to be the main avenue for civil rights protections or developments for the foreseeable future. Might not be. All right. What that means is the political branches will have to become the avenue. So who is elected to the chief executive position, who is elected to the legislative branch, at the state levels and at the federal levels become crucially important. And that means minorities who can be very frustrated in attempting to get things through a Democratic majority must find allies. And people who are part of a majority must ally with political minorities to help ensure the advancement of civil rights. So if you are concerned with equity, if you're concerned with civil rights, and you're concerned with the government of the United States and our legal system, then the current moment in history tells us that we need to empower ourselves with a legal understanding and to launch ourselves into the political sphere to make the difference that we want to see in the world. Thank you very much, and I wish you good luck, stay healthy, and be powerful.